Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Daniel H. Sleet, Chief Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Thank you, Marshall. Good morning, everyone. Welcome to this session of the Second District Court of Appeal. We have a few cases on the docket, three of which that are consolidated. As many of you may know, we allow 20 minutes per side. And if you are the appellant, you have up to 5 minutes of rebuttal. So once you introduce yourself, let me know if you want rebuttal. You'll get 5 minutes maximum. We have read everything. That includes everything in the record, transcripts, and everything that's filed. We're very familiar with the cases. Since we're on Zoom, we do about half Zoom, half live oral arguments. So sometimes it gets a little bit complicated, but if we do ask a question, just please make sure that you stop talking, because we don't trick you with our questions. We really do want to know the answers. So let's try not to talk over each other. We are going to proceed with the docket, the cases that as they appear. We have State of Florida versus Robert Ronald Kilburn and Holly Ann Moreno and Arthur Joseph DePaul. Those three cases are consolidated. Normally, if they were different cases, you all have 20 minutes, but we are not going to do 60 minutes of oral argument on these cases. So unless there is something different than a bit breath tube that was inoperable, that was sent out to be, which is the issue, repair to maintain, unless there's something different than that. So we're going to limit both sides to 20 minutes. Are you ready to proceed? The state ready to proceed? Ms. Klein?
Is my camera? I don't see myself.
I don't need.
Oh, wait a second. It's me. It's me.
There you go.
Make it made.
You need any time to set up?
I think what happened is it just switched. I had my laptop up here and it just switched to a separate camera. So I'm just going to move her over, slide over a little bit.
Let me know when you're ready. So.
Okay.
Would you like some rebuttal?
Excuse me?
Would you like rebuttal time?
Oh, yes, sir. Your Honor, I would like to reserve 5 minutes for rebuttal.
Okay. All right.
All right. May it please the court, this is Catherine Klein, the Attorney General's office in Tampa, representing the state in this proceeding. As the court has mentioned, this is a consolidated case involving three separate cases and the suppression of the breath test results from the same intoxilizer machine. The state's position is that the trial court erred in suppressing the breath test results in these three cases because the breath test results conducted on this intoxilizer were approved tests conducted on an approved instrument and were performed in substantial compliance with the methods approved by the Department of Law Enforcement and were admissible under the Florida's implied consent statute.
Ms. Klein, is it it's your position that after the device was, I'll say, fixed for the moment, it was operating properly?
Yes, the state's position is that once the breath hose was replaced by the department inspector, he conducted a department inspection, which was required before putting an instrument back in evidentiary use. Here, he validated the instrument, and it was approved for its accuracy and reliability. And this is according to Florida Administrative Code 11D8033, which provides that a department inspection performed in accordance with Rule 11D8004 validates the approval, accuracy, and reliability of an evidentiary breath test instrument. And that once the instrument...
If FDLE sends it out to be fixed, who certifies that it is operable?
I believe that it would come back to the department and they would do a department inspection. That's what I think. I believe
So let me ask, are you conceding it was a repair?
No, the state's position is that this was maintenance, which could be performed by the department inspector.
But how can you maintain a broken tube? It was inoperable. So it had to be replaced. Maintenance just means a proactive type of habit of maintaining in terms of just, does it work? Here, you would agree it didn't work. And, the first guy said, yeah, it needs to be repaired, but we're not relying just on his interpretation of needing to be repaired. It's this tube was taken out of the machine and not put back. They put a new tube in there. So given the fact that FDLE, and I don't know why, because trust me, it would be economical and expedient if they allowed FDLE to do the repairs of their own machines. But apparently the legislature in 2015 amended the statute, and neither one of you cited this, but the legislative history indicates on 11D-8.002(13), it removed the Department of Law Enforcement from the definition of an authorized repair facility because the department only performs maintenance on the breath test instruments and does not perform repairs. So my question is, do you concede it was repaired?
The state's position, as it was below, is that this was a maintenance that could be performed by the department inspector, and then, as the state argued below, likened it to a replacement, say, of a tire on a vehicle, which one would consider a maintenance, as opposed to working on the internal workings of like an engine or something. And here, this replacement of the breath tube only involved unclipping, the old, the conceitedly broken breath tube and replacing it with another. Did I hear a question? I can't hear Judge Black.
Great.
I can't hear the question.
Still can't.
I just heard a voice. I don't know who's. If Judge Black could speak again.
Can you hear me now?
Yes.
Okay. I feel like I'm yelling, but if you're, then we're on the same page. This repair, we're good. The repair, unless someone does something to swap out that piece of equipment, it is non-functional. It cannot be used. It's broken. I mean, isn't this sort of like if a light bulb burns out? It doesn't do it good to take it out and dust it off. If it's broken and burned out, it needs to be, quote, replaced. And isn't that what happened here? It was replaced. The equipment was replaced.
The breath hose was replaced by the department inspector. And then the department inspector conducted a department inspection, which under the code also validates this machine for evidentiary use. So even
if we find it's a repair, you would agree based on the rule as written, only an authorized repair facility can conduct a repair, correct?
I mean, I know neither of these things are defined in the statute.
No.
Yeah.
I don't think it needs to be.
Or the
If
code.
you agree it's a repair, the statute identifies authorized repair facilities and excludes FDLE as one of them, correct?
The code does not include the FDLE as an authorized repair.
Okay, good. Now we're on the same page. So if it's a repair and it goes out to an authorized repair facility, and comes back. I know there's a language in the rule 11D 8.006 about taking it out of evidentiary use. I assume that's what this is. So they send it to a repair facility. Where in the code does it say that once it's returned back, that an FDLE inspection certifies the machine after repair to the point of being
The portion of the code that simply says, I mean, and granted, this code probably could be a little more explicit, but it
I
is
agree.
administrative code. But the portion that says it's 80033, a department inspection validates an instrument for evidentiary use and accuracy for accuracy and reliability. So once it passes the department inspection under the code, the machine has been validated. So under your scenario, if it had gone out, say something was wrong with its, I would assume something wrong with its internal mechanism that measures, the chamber that measures the actual breath levels, and I think that what would happen, it would come back, from there, it would get a department inspection, then it would go back to the agency, which would be the sheriff's department, and then it gets another inspection. So this inspection by the department, at least under this provision of the code, would validate the machine either way, whether you considered it a repair or maintenance. And that goes back to the statute, the implied consent statute, which only requires substantial compliance with these administrative rules. And the state's position is that even if it was considered a repair, there was substantial compliance when it was approved by the department inspection and validated for evidentiary use and sent back to the agency, who then did their agency inspection. Is there another question? I'm having problems with Judge Black.
Yeah,
Couldn't decide whether it's repair. I'm sorry, Judge Black's trying to talk and I can't hear him.
Oh, now you're frozen.
Whether it's a repair or maintenance, in the normal course, each machine is tested at least on a yearly basis. Is that correct?
Yes, and it's tested on a yearly basis. It's tested, it does, I think it's monthly inspections by the agency. In fact, that would be the next level down, the sheriff's department inspector.
If I heard you correctly, whether the department took care of it or it had been sent out, someone within the make sure the machine is now functioning properly.
I'm getting a little, the department inspector would and did in this case perform the department inspection, and also specifically testified that he tested the breath tube. I know there is some discussion about this breath tube having to be heated. It's heated, once it's clipped in. So he tested it to make sure that it was heating properly. And this is done by, viewing some like a diagnostic screen. And he testified to that at it's record 229 in the Kilburn case. I know there's 3 different cases here, but that's where the department inspector says that he checked that the breath hose was heating properly after replacement, and that this procedure is part of his department inspector training. They're also allowed under another provision of the code to remove that the department inspector and the authorized repair facilities can both remove that top panel of the machine to access this screen and the breath hose. So again, the state would repeat that this department inspection was thorough and validated this machine as a reliable and accurate breath test instrument. and that under the administrative code, the machine was in substantial compliance. They was in substantial compliance with the administrative code rules, which govern the conducting of these breath tests.
Well, the judge did do an analysis of substantial compliance, and she found this was a repair. And there's nowhere in the code where FDLE can certify that a repair was done properly. I totally agree with you that the code is not well written, trust me. But we've got to follow the plain language of this code. They're not, FDLE is not allowed to repair it. So how is their subsequent inspection substantial compliance when they're not allowed to repair and it was repaired?
Well, first I would submit, oh, excuse me, that the trial court didn't do much of an analysis of substantial compliance. She simply found this was, she found it was a repair and then found it wasn't in substantial compliance, but then she didn't do any analysis. The state, as the state argued in our briefs, she held the state to a strict compliance standard rather than a substantial compliance standard. And there was no evidence in this, there's no fact supporting that this was not a reliable and accurate machine. And it's different from the case that she cited in her order, Pollock, in which the machine was substantially modified by, I can't remember this department. I think it was probably the agency, the actual agency did, where they had like drilled a hole into a sensor device and substantially modified. And in this case, nothing was substantially modified, where simply a hose that was reportedly bent and not allowing enough breath to go into the instrument was replaced with a new hose by the department.
Maybe we're missing the forest for the trees. Substantial compliance with what? Does it have to be substantial compliance with repair or maintenance, or substantial compliance with putting a properly operating device out there?
I would say that substantial, that the device was in substantial compliance with the rules, and that, excuse me, lose my train here. And like in, this is a case I cited in my brief, State v. Kleiber. This case had to do with, albeit blood testing and the administrative rules that involve blood testing. And in that case, the person who drew the blood used a dry piece of gauze instead of an iodine coated strip because that person was allergic to iodine. And in Kleiber, this is a 5th District case, 2015, that the court found that the trial court had improperly applied a strict compliance rather than a substantial compliance test, because minor deviations from the rules will not prohibit the test results from being presented, as long as there is evidence from which the fact finder can conclude that the test itself remained accurate. And even in her order, the trial court in this case never ruled that there was any showing that these tests were inaccurate. She simply found this to be a repair and found it not to be in substantial compliance. And
well,
the
but
state was,
if the rule prohibits FDLE from doing a repair after 2015, and FDLE did the repair, how is that a minor deviation from the rule? It seems clear.
But yeah, I would think you'd have to, first of all, you'd have to take all the rules as a whole and finding that this is a substantially compliant machine, plus the
Can you hear me now? Okay.
Hear me better now?
Yeah.
yes.
If FDLE is not supposed to do the repair and they do the repair, how is that substantial compliance? It seems to me to be substantial non-compliance.
Well, first, again, you'd have to go back and assume, I mean, that this is not a form of maintenance that the FDLE is permitted to perform. And I would point the court to,
We'll
It's
let you know
exhibit-
you're at 16 minutes. You can use your time as you wish.
okay, I would just briefly point the court to Exhibit I, which is a instrument processing sheet that, and it's record 97 in the Kilburn case, Exhibit I. And it's the instrument processing sheet from FDLE for basically the inspection and breath tube replacement that the inspector performed here. And they have a form which reportedly at the bottom of the form says that it's from January 22, and specifically under maintenance, they list breath tube replacement. And I think we have to take, I know we can't defer to the administrative agency's interpretation, but I certainly think this should have been taken into account, that this is considered maintenance along with battery replacement, dry glass, regular replacement, other, and by the Florida Department of Law Enforcement. And I guess I will reserve the rest of my time for rebuttal.
All right, yeah.
Thank you.
very good.
Thank you.
Thank you. Mr. Harrison, good morning.
Good morning. Can you please the court just to check, can everybody hear me?
Yes, sir.
All right,
You hear me?
perfect.
Okay.
The state basically is asking this court to reweigh a factual finding that the trial court made that this was a repair. And states tries to oversimplify as far as what happens with dealing with the breath hose. In the trial court, as a trier of fact, we actually had an intoxilizer there in the courtroom. They were able to look at it. They could see the panel that needed to be unscrewed. And when the breath hose is connected to the intoxilizer, it has to be connected in two different places. Number one, there's a plumbing part where the air goes in with a hose connects through I guess an O-ring. And then there's an electronic part where it plugs into a circuit board. And then when it's everything said and done, they have to go through back and make sure that it's heating properly. So we don't know what procedure was done. The repair person from FDLE didn't recall where he was learned these procedures. Make sure that there's voltage or air flowing. If that's not evidence to support the trial court's finding of repair, I don't know what is. So we got to sit there and look at, is there evidence here for the trial court to say that this was a repair? And
If it's working properly after the fix is done, does it really make any difference what you call it?
well, we don't know that it was working properly. All we know is that it passed the inspection that was done. But as we brought out in the record, when the inspections are done, there is a side port to the intoxilizer. So when they put the simulator solutions at the various levels, those aren't introduced through this breath tube. So none of those inspections test to see if it's heating properly, if the voltage correctly, if the air is flowing correctly. So those would all be things for the authorized repair facility. So on
Mr.
any
Harrison,
individual,
if I may interrupt, there is no evidence that those devices were not working properly after the fix. Correct? There's nothing in the record.
after the fix, there is no evidence that was in the record that any breath test conducted after the fix was correct or incorrect. The record was silence out of that because there's no way to actually know if any given breath test is done correctly. The only way that we know is if we follow all the procedures to know if we have a reliable result. So
Klein tells us that the machine after it was fixed was certified to be operational.
they did a department inspection after the fix, and it passed the department inspection. There's no question about that. What I'm saying is that department inspection did not test the breath hose. It's testing through the side port. And so there's nothing in the department inspection procedures that they went through that will tell us, is the hose heating properly? Or is the air properly flowing through that? None of those are through the promulgated rules, which is why we would go back to the authorized repair facility, because they need to make sure that this is operating correctly. Because this is not like a mouthpiece you're just blowing through. It's got to be heated, and heated has effect of dealing with dealing with the chemistry. I mean, there's a reason it has to be
Mr.
heated. and you have to
Harrison?
make
There's nothing in the record to indicate that it would have made any difference with testing, because there's nothing there, as Judge LaRose pointed out, there's nothing in this record to indicate that the machine wasn't operational at all times. I hear what you're saying about other testing that might have been done, should have been done, might have found this or that, but we're not working with any of that.
That is correct. We do not know that it was working correctly. We do not know that it was working incorrectly. But when the state, the point that I understood from the state was they're saying, well, we did these inspections, so we know that the intoxilizer was working correctly. Therefore, we should say that there's some type of substantial compliance here, and that just, the record doesn't establish that. And so I don't have to show that it was working incorrectly. I got to show that it was not in compliance with the rules.
If it had
Well,
gone,
let me ask a question, because I looked at your frost of, I don't know how to pronounce it, Gutschall. He does talk about what's normally done. Is there anything in the record where what you have just said, what should be done following a repair in terms of whether the hose heats up properly, et cetera, where Mr. Gutschall says that was not done when it was returned? I mean, all we have in the record is it was working properly, but you're making an argument that there's more to be done after a repair. There's more to be checked. Is it in the record that either one of these FDLE reps, when it was returned, they didn't do that?
What Mr. Gutschall, testified that following the installation of the new hose, he needed to go back and do some diagnostic checks to check some voltage. As far as the procedures and where he was taught that, and were those properly, none of that is in the record.
I don't know if there's a protocol that an outside company would use that the agency representative did not follow.
We do not know what the protocol would be from the authorized repair facility to do this. All we have is Mr. Gutschall testified that he was taught someplace on how to do this and can't remember where. But again, it just goes back to, he wasn't authorized. The rule is very clear. We don't have do-it-yourself repairs on a device where somebody's liberty is at stake. And then when we go back to substantial compliance, dealing with Judge LaRose's question about substantial compliance, if we go back and look at the Robertson case, which I believe both of us cited, that was a Florida Supreme Court case. So it was dealing with blood. The person who did the analysis didn't have a permit, but was under the supervision of somebody who did have a permit. And the state argued substantial compliance. And the Florida Supreme Court in Robertson said, while there are substantial compliance clauses and separate savings clause in 316.1934, by their own terms, those clauses only apply to the methods approved and the approved techniques and actual testing procedures. There's no reference whatsoever to substantial compliance in connection with the licensing clause. And so the methods is what the breath test operator does. And that has to be done in substantial compliance. But there's no substantial compliance for permitting, and there's nothing there dealing with repair. And then as to dealing with the suppression, this was something that wasn't really argued either below or sitting there dealing with the state. Our client, it's consent that, it is only to an approved test. And if it's not an approved test, there's no way for it to be voluntary consent, because it's based on misinformation, because their consent is only applied, or they were submitting to an approved test.
For 5 years hence, and it's tested regularly and never has a problem, and someone blows into it 5 years hence, and someone is going to do a painstaking history, what has ever happened to this machine, find 5 years prior it was fixed by an agency employee. And suppression 5 years hence would be a problem.
At some point, if it's a do-it-yourself repair, if they want to continue to use that device, it needs to be somehow validated by the proper, repair people. That way that we know that, is it heating properly? Do we have the right voltage? Is the air flowing, correctly? And so that's just one of, the whole idea behind implied consent was they have these regulations where only certain type of devices can be used. They have to go through certain regular maintenance. They only can go through authorized repair facilities. And if the state complies with all of these rules, then the breath test comes in automatically, without having to bring in an expert. In our case here, the state took the shortcut, and didn't follow all the rules and elected to do it in-house. And so on this particular device, they need to somehow, correct it. That's not here before the court, but I would think that if it went back out to a repair facility, they looked at it, they said, it's installed correctly, or we've corrected the installation and it's now working correctly. From that point forward, they would, that would be an approved test. But right now, we don't have that. A lot of the stuff we just don't know about what the procedure would have been happened from the authorized repair facility, because that's outside the scope of the rules. All that FDLE or agencies are doing these testings through the side port to make sure that it's working correctly. If it's not working, if it doesn't work, somebody else has to do the repair.
Under 11D804, the inspection validates the instrument's approval for evidentiary use. And we all know that if it is under 006, if it's taken out for evidentiary use, the agency shall conduct agency inspection. So if the inspection validates the instrument's approval for evidentiary use and it was inspected after repair, and we don't have any other evidence that it was improperly repaired, why can't we find that to be substantial compliance?
Well, substantial compliance is how it's operated. But if that were the case, we're looking at one part of the rule in isolation, that basically would say we're going to have authorized repair facilities, but we don't have to use an authorized repair facility as long as we do a department inspection after we do our own repair. And that would just totally eliminate the authorized repair facility. Because I think that there's a provision somewhere in 11D-8 that says, any instrument coming back from an authorized repair facility has to go through the department inspection. Well, all of those provisions would be absolutely meaningless if they could just do a department inspection to validate anything they wanted to do. And when we interpret, the rules or statute, you're not supposed to interpret it in a way that makes a provision meaningless. And they're basically, that interpretation that we can do a department inspection makes the authorized repair facility provision, meaningless. And excuse me a second. And even under the implied consent statute under the 1932, under what the rules are supposed to cover, it specifically addressed, to for the FDLE is to create a rule for the authorized repair facilities for approved. Let's see. They have the authority to approve repair facilities for the approved breath test instruments, including the authority to set the criteria for approval. And that would be in that subsection P in 316.1932. So I just think we would just be eliminating the need for authorized repair facilities if all we had to do was validate it with a department inspection, which may or may not test the part that was repaired. And if there's no other questions, I don't need my 20 minutes or 60 minutes like you originally thought.
All right, sir. Thank you.
Thank you.
Ms. Klein, you have 3 minutes.
We do know that this machine was
Can
working.
I ask you a question to follow up on something Mr. Harrison said?
Sure.
Did your people make any attempt to contact an outside repair facility?
There's nothing in the record that I have seen that they contacted an outside repair facility.
Where I'm going with this, if they had called an approved facility and this facility said, we don't need it, just do A, B, and C, and your people did A, B, and C, that probably is very close to being substantial compliance.
I would agree, that would be substantial compliance. I think that the machine here, or the testing, was in substantial compliance. The machine had been the hose had been replaced, and the department inspector even specifically tested whether it was heating or not, like Mr. Harrison has spoken about. There's no evidence that it was not working properly after this hose was replaced. And this was in substantial compliance with the administrative rules and the implied consent statute. And I would also mention that the department inspection, according to Mr. Goodshow, this is record 231 in the Kilburn record. It also involves a portion of this test is they do a mouth alcohol test, which they breathe through the hose. From what I can glean, they do a test where he hasn't had any alcohol, and they do a test where he has some alcohol in his mouth, and they breathe through the hose. And this is part of the testing in this department inspection. So it's not just
once it came back from repair, did FDLE do anything other than the inspection that's set forth in the rules? Nothing in additional to determine whether the repair was correct. They just did their.
I think maybe the department inspector Goodshow mentions that he let me see if I find it here.
I recall him testifying to what he routinely does, but I don't recall him testifying that he
said,
did that
in this
routine
case,
repair.
Well, I have it in my notes anyway, that at record 229, he testified, he checked that the breath hose was heating properly after replacement, and that procedure is part of the department inspector training. And the machine passed agency inspection also upon its return to the sheriff's department in Sarasota.
Well, I think it seems to me like he's talking about the hypothetical situation, because its question is in 228, and you don't do any type of checks for electronic to make sure that green chip is working. And he says, I do plug in when I replace the breath hose, I do plug it in, both in the instrument. I mean, he's telling what he normally does. Doesn't indicate he did it to this machine when it was returned.
I guess, I mean, I'm reading the transcript. You could interpret it, I guess, that he's just saying that in general, but he's not saying that he didn't do this inspection of the breath hose in this case because it's part of his department inspection. But and he's had training on how to do that. I don't know why he would have training on how to do that if he's not permitted to do it. So the state, I know I'm probably running out of time here. The state would ask this court to find that the breath tests were conducted in this case using Intoxicator 1344 were approved tests conducted on an approved instrument. The tests were performed in substantial compliance with methods approved by the Department of Law Enforcement. And accordingly, the breath tests were voluntary under the Florida's implied consent statute, and the results were admissible at trial.
Okay. Thank you very much. Good to see you
Thank you.
both. Happy holidays. You've given us a lot to think about.
Happy
Enjoy
holidays.
enjoy the rest of your day. Thank you very much.
Thank you.
So we are now going to move to looks like the fourth case, but really our second case. Interest Holdings, Inc. versus Nancy R. Douglas. Counsel ready.
Attorney Dogali, you have to hit accept so we can transfer you over. Attorney Dogali, thank you.
Morning, Mr. Dogali. Do you wish to reserve any time for rebuttal?
Yes, sir. 16 and 4, if that's pleases.
Okay, we'll do that. You may proceed.
Thank you, Your Honor. If it please the court, I'm Andy DeGalley, represent the appellant here, the respondent below. It's for sound policy reasons that the law still requires strict formalities when executing a will or when probating a purported lost one. In this case, arises out of a will that was downloaded from an internet website. The downloaded form includes fill-in information. You can fill in data like the identity of the personal representative or the beneficiaries. And we know that on a particular date, the decedent downloaded that form and entered some data into it on his phone. We know that 3 hours later, he signed a will. That's about all we know. No mystery has been cleared up. There shouldn't be any mysteries after a purported lost or destroyed will is probated. And what we end up with in this particular case, the record includes 5 versions of the so-called lost or destroyed will. There's the unsigned blank one on his phone, October 11th. There's the unsigned blank one that has some data filled in, also on his phone, October 11th. There's a signed version that was accepted into probate that includes some handwriting signed on 3 hours after it was downloaded on October 11th. There's a signed version, there's purported to be a signed version dated October 11 that has no handwriting. The appellee suggests that the handwriting necessarily or presumptively arose after the original signing. There's no evidence of that. So the idea is, if that's true, there's also a version that was signed on October 11 and does not have handwriting, but nobody's ever seen it. And then there's an unsigned blank version with no data that was emailed to a friend of the decedent on November 9, only a few days before he died. Now, whichever one of those might be a will, if any, the process of probating that will is a substitute for the original, which everyone agrees the original no longer exists, is established or governed by 733-207. The kind of uncertainty created by ambiguously drafted or executed or preserved wills is exactly what that statute is intended to preclude. The statutory scheme basically has two parts to it. One is you either have two disinterested witnesses who can testify to the specific content is the term of the will, or you have only one, and you have what is called a correct copy of the will. In this case, neither one exists. That is, there were 0 disinterested witnesses to testify about the content of the will. Nobody testified about the content of the will. And the correct copy of the will, so-called correct copy, also does not exist. Now, the correct copy concept is laid out in a Florida Supreme Court decision called Parker's Estate that's cited in the briefing. The appellant suggests here that Parker's Estate is controlling here on the question of whether this is a correct copy. The Supreme Court of Florida determined that under this statute, correct means identical. That is, it is in the nature of a carbon copy or a photocopy. So under Parker's Estate, you can't have a version of the will that is admittedly different than whatever the original was and call it a correct copy. Now, when probating these things, you have the disinterested witness concept, 1 or 2, and the correct copy concept. With the disinterested witness, the appellee suggests that what this court can do is disregard 733-207. Now, there's no authority for that, but the idea is it's called other evidence, or the trial court properly took evidence like testimony of a disinterested witness. There is nothing anywhere that authorizes the trial court, to have disregarded 733-207 and accept some substitute evidence. And one decision of 5th DCA, Brennan, is cited in the briefing, it's totally irreconcilable with the suggestion that 733-207 can be disregarded or some other type of evidence can be accepted, because in that case, it was admitted there was a correct copy. There was no question about it. It was exactly the same. It was an identical copy, but there were 0 disinterested witnesses. Absent that full compliance, there could be, under Brennan, no compliance with the statute, and whatever that petitioner wanted to propose would prove up the content of that will, other than just a correct copy, was not enough. That case is indistinguishable here from the suggestion that the trial court properly listened to something else. Now, this something else, the only authorities cited for the proposition that the trial court could take up other evidence or something like a disinterested witness. There are 2 decisions, Dean's Estate and Burton's Estate. Dean's Estate is 100% a spoliation case. Burton's Estate is 100% an undue influence case. And there is nothing wrong with accepting statements of a testator or decedent to show undue influence in drafting a will, or to show spoliation of a will that everybody agrees once looked a certain way. That is, the original version is well documented and can otherwise be established. This idea that you don't need a disinterested witness, the way the appellee creatively approaches that is by suggesting that the decedent himself can be the disinterested witness. Now, that can't comply with the statute for any number of reasons. One is the statute squarely requires that this be witness testimony, and a dead person cannot be a witness. Under the evidence code and other authorities cited in the briefing, a witness is someone who takes an oath to give testimony, and reciprocally, testimony is something somebody attests to while under oath before a fact finder. In this case, a decedent can't take an oath, and a decedent can't give testimony. And with respect to and he can't be disinterested because it would be his own will. So he has an interest in confirming that whatever his intentions are carried out. And then finally, the suggestion is that these are statements of the testator that can be admitted. It's true, you can admit statements of a testator in an undue influence case, but here, these aren't statements. What is described is the fact that this unsigned form exists on his cell phone, the decedent's cell phone. constitutes a statement by him of what his intention was. Now, that doesn't make any sense because we know that the will that's been probated is not the one on the phone. It has handwriting on it that wasn't there before. It was added sometime. And the blank one on his phone doesn't have all the information filled out in it. And so with respect to the Dean's Estate decision that's cited here, as I mentioned, that really is just a spoliation case. The idea that you could set aside or ignore 733-207, citing Dean's Estate and Burton's Estate doesn't make any sense because both of those cases predate the statute by more than a decade. It is, you can't rely on an old case that predates a statute as a basis for ignoring the statute or deeming it inapplicable. In this case, there's another decision cited in the briefing called Lowy that addresses Dean's Estate and says the Dean's Estate is a spoliation case and it is 100% distinguishable. It is it's called a conceptually and practically completely dissimilar issue. That is, the reestablishment of a lost or destroyed instrument under 733-207 and spoliation are two totally different concepts. And the Lowy decision said Dean's Estate just does not apply in a reestablishment or an attempt to probate a lost or destroyed will case. Now, with respect to the correct copy concept, the appellee asks the court to accept the proposition that, okay, it's not quite correct. That is, that you should ignore that there's handwriting on it because the appellee assumes that wasn't there when he signed the will. And it would be a correct copy, and parenthetically, of course, if you ignore the handwriting, it would be. There's no authority for saying that you can ignore parts of it and accept the rest of it as a correct copy. That's irreconcilable with the Florida Supreme Court's case in Parker's estate. Now, in addition to saying you should ignore the pages that have handwriting because the rest of it's a correct copy, we also know that the will that was accepted into probate has the wrong pages in it. The first page is missing, page 1 is missing, and it has a page 1 attached that is not part of the will. It's part of the downloaded instructions on how to fill one out. And so not only is this is a correct copy if you ignore the handwriting, it's also a correct copy if you ignore the fact that 2 of the pages are wrong. Now, the issue of spoliation arises by virtue of these 2 pages and other issues. The trial court decided that spoliation here is not an issue. She did not apply any evidence to any concept related to spoliation, even though Dean's Estate squarely applies here for that reason. Dean's Estate says that the entire statutory scheme about reestablishment of a lost or destroyed instrument exists to prevent a spoliator from profiting from the spoliation of a will. In this case, Ms. Douglas, the petitioner here, destroyed the will herself. She admits that she went to his house, Stephen Watson's house, the day he died because she knew it was an important instrument and she knew she should preserve it. So she went and got it that day and she held it for a few weeks. Then she says after a period of time, it still had the smell of cat urine in it. So she would retain only the original 2 signature pages and destroy the rest. And she said she photocopied the rest. Actually, what she photocopied was not page 1. She photocopied the instructions, and those are there instead of page 1. And she disregarded all those other pages, and then she says saved the original 2 pages. So there's no question that the spoliator, if you will, is the one asking to disregard that spoliation and reestablish the will that she herself destroyed. Now, other than being totally contrary to Dean's Estate, the statute, the judicial decision, the decisionary authorities relating to spoliation are laid out, and for example, the Golden Yachts case and others, that if there is a duty to preserve, and there was, she agrees with that because that's why she went there and got it. And if it once existed, we all agree there once was a will. And if it was material, well, it has to be material because we're trying to reestablish a lost or a destroyed instrument here. In that instance, a presumption arises against her that that document was unfavorable to her. And so what ends up happening is she either can't probate the will because she can't reestablish it. In that instance, Mr. Watson died intestate and she does not inherit, or the presumption should work against her effectively like an estoppel and prevent her from probating that will because she's the one that would profit from it. And again, she would not inherit. Now, either outcome is not inequitable because she's the one that destroyed it. Now, at the trial of this cause, the respondent, we introduced a lot of evidence about not only her deliberate destruction of this original instrument, followed by her effort to reestablish it, but countless acts of malfeasance by her that should go to the issue of the presumption that works against her and whether she should be able to benefit from her own spoliation and reestablishment. In addition to destroying the will, she destroyed financial papers. She removed jewelry from his home and kept it 5 months. We don't know that she turned over all of it after 5 months. She spent $4,500 of the estate's money on herself for gas and restaurants and Home Depot, using the decedent's credit cards. She used his debit card and falsely signed his name to take cash. And she had him cremated rather than the will that said he wanted to be buried. And that cremation saved a lot of money for the estate, which she will now inherit 75% of. And the list of malfeasance, she represented to the funeral home to make arrangements that she was a sister of the decedent, and she is not. She recommended that she's next of kin, and she is not kin. The next of kin is the asinore of my client, and that's the only living kin. He's the gentleman that should inherit here, or his assignee being my client, because of all the people that should not, it would be Ms. Douglas. There were other incidents. She didn't fill out an inventory. When she finally did, she left the jewelry off. She left the safe deposit box off. We don't know why. All of this evidence should have been accepted and applied in an analysis of whether spoliation should work against her. The trial judge found that spoliation was not an issue. She deemed it immaterial. It can't possibly be immaterial, but it's clear there are no findings about it. She has no fact findings, so there's nothing for this court to evaluate from an abuse of discretion standpoint or whether there was competent substantial evidence. Rather, it's just a question of law, whether she should have considered that issue and the presumption that works against Ms. Douglas. And this court should first reverse the finding, the ruling by the judge, that this will is accepted into probate, and should actually direct the trial court that no compliance with 733-207 occurred. There was no disinterested witness. There was no correct copy. Therefore, this will does not get accepted into probate. And then an entirely separate basis for refusing to accept the will into probate would be the presumption that works against her as the spoliator, especially when compounded by other acts of malfeasance on her part. If the decision is not to render or direct the judgment and to send it back for more findings, the trial court needs direction that it is time to accept that evidence and apply it that relates to her acts of malfeasance, but mostly to her capacity as a spoliator and one who should not profit from whatever she's done. And so, Your Honors, it's probably most of my 16. If you have any questions.
You're at 16.
Thank you.
Great time. All right, you reserve the rest?
Yes, sir, please.
All right. Mr. Baloo, good morning.
Thank you. Good morning. May it please the court. My name is Brandon Baloo with Johnson Pope. I represent Nancy Douglas in this case. She was the nominated, she is currently serving as personal representative under the will dated October 11th, 2022. That was admitted to probate through a correct copy in this case. The will was signed based on the copy admitted to probate on October 11th, 2022 by Stephen Watson. The whole issue here is, in a lost will case, is to confirm that the copy of the will offered for probate is a copy of the will that the decedent actually signed and accurately expresses what the decedent wanted to have done with his property after he passed away. And that was what we sought to establish here. The first argument offered by appellant is about the correct copy issue. I don't know that I understand the argument about the different versions of a correct copy that are being offered. The correct copy that we offered for probate and that was admitted to probate was the copy that my client, Nancy Douglas, made of the will, of the original will that she found in the decedent's home. She found that will in a safe, I believe, under the coffee table in the home on the date the decedent died. She made she retained the original for a period of time. There's evidence in the record based on testimony that the will had cat urine and cat fecal matter that had gotten into the pages of the will that affected my client's, caused her to have an allergic reaction or a bad reaction to it. She tried to address that, unable to do so. A few weeks later, she threw away the original pages of the will, but for the original signature page and the self-proving affidavit. She retained those pages. Why would she do that? I'm not sure, other than she did not know, her testimony was she did not know the importance of a complete original will. As we all know, there are other documents in Florida in the law where you do not need an original ink on paper document for it to be effective. For example, a revocable trust does not require an original document. But
you're telling us, I assume, that she took a picture of each page, correct?
I believe the testimony was that she made a copy of each page on a copy machine of some sort, except for the original pages of the signature page, the pages with the actual ink on them, the signatures. She retained those pages.
The pages that she copied follow seriatim.
Excuse me, I didn't understand the question.
To page 1, page 2, page 3, page 4 signature pages.
Yes, she made a copy in order of every page that she found in the decedent's unlocked safe or strong box that was under his coffee table.
What about the supposed lost page, or absent page?
So page 1 that's been referred to appears at record page 457. And I know that because it was the copy downloaded from the phone. At the bottom, it says page 1. The only text on that page is the title, The Last Will and Testament of Stephen Lewis Watson. Those are the only words on that page. That is not a vital part of the will or has no terms on it. So I'm assuming, well, it's the only thing we can do because we don't know, that the decedent did not find that page important because that page was not with the original will that my client found in his home. I don't think that has any bearing on the correct copy issue. The correct copy that we offered for probate, as I said, was the copy of the original signed will that my client found in the decedent's home on the date of his death. The different versions that were found on the decedent's phone were not actually different versions. The text of the will found on his phone, the terms, who the beneficiaries are, who the personal representative is to be, are the exact same as the will that was signed on October 11th, 2022, because we see no difference in the terms of the copy of the signed will and the will that was found on the decedent's phone.
So help me understand my recollection is there's one handwritten note.
There was a handwritten, a cross out and a addition to the will as to who the contingent beneficiaries were to be on the version that my client found in the house. So had she found that original, well, she found the original will, had she not destroyed the original pages, but for the signature pages, that will could have been admitted to probate with the handwriting on it. And the only issue at that point,
we don't know if the handwriting was put on before or after C. Is that fair?
Correct. We do not know when the handwriting was inserted on the will, but the point is with handwriting on a will, it will be admitted with the handwriting, and then the issue would be what's the effect of the handwriting? Does it alter the terms? In this case, it doesn't. It would never be material because the primary beneficiaries survived the decedent, so the contingent beneficiaries would never take, and that's what the change in the handwriting was here. But if it were something material, the court would then be asked to determine the effect of the handwriting. Is it ignored or does it have some effect? But that has no bearing on whether the will itself is admitted to probate. And in this case, it's just part of the correct copy that was in existence at the time of the decedent's death. It doesn't make it not a correct copy. It's the copy. I don't know how many different ways to say copy or correct copy. It was the version that my client found in the safe on the date of his death, and she made a copy of that. That's what we offered for probate, and that's what we had admitted. The other copies, I think saying the word copy over and over again adds some confusion, but the other, I guess we'll say the unsigned copies found on the phone are relevant here because they establish that the version downloaded on the decedent's phone on the very date the original was signed, October 11th, 2022, was the same. That he downloads a copy of the will from trustandwill.com, an online service where a person can prepare a do-it-yourself will. He downloads it on October 11th, 2022, and then he signs it based on the copy of the signed version we have on that same date. There's no difference in the terms between what was downloaded and then emailed to himself and then signed. We know that from the testimony of the digital forensic analyst who testified to establish the copy as the identical version that was signed. At the trial court level, I argued this was akin to a lawyer reviewing his or her file to determine whether the will offered for probate was a correct copy. It would be nearly impossible, unless maybe it was recently done, for a drafting attorney to have especially one who prepares a lot of wills, to have a very clear memory of the exact terms of the will prepared. That attorney would most likely go review his or her file and find an unsigned copy there possibly and check that against the will that was offered for probate and say, yes, the content is the same, therefore that is a correct copy, which that would also prove the contents, which gets into the second point raised of the disinterested witness issue. The disinterested witness, if that requirement is, as appellant is arguing, it would be impossible, nearly impossible, for any copy of a will to be admitted to probate if it is a disinterested witness who can testify to the content of the will signed, and that disinterested witness also signed as a witness. The evidence testimony was that this will was signed at I believe it was a UPS store where there was a notary. A neighbor went to serve as one witness and another UPS employee served as the other witness. These witnesses aren't going to review the will. They're not going to memorize the content of a will they have nothing to do with other than standing in as a witness. We had testimony that the decedent emailed a copy of the will, unsigned copy of the will, that was exactly the same as the one that was signed and admitted to probate to Bridget Tucker. She was the nominated personal representative, but declined to serve in favor of Nancy Douglas. But she received that copy. He told Nancy Douglas that he was going to draft a will and execute a will that benefited her and Bridget Tucker. These were his closest friends. There's no doubt that he would have wanted to benefit them based on the evidence, as they were the closest individuals to him. Nancy Douglas found the will exactly where the decedent told Bridget Tucker the original will that he signed would be. He told her it would be in the safe under the coffee table. Bridget Tucker provided that information to Nancy Douglas. She went to the house, found the will there. That would be proof that the decedent executed that will in that form that was there. There is no other different version here. There is no other version with different beneficiaries or with a different nominated personal representative. This is the only one offered. The testimony presented establishes the content. Here, there is no doubt and no concern that the decedent wanted anything other than the content in this will. We have the requirements in the statute and the case law to establish the content of the will, to preclude any doubt as to the content of the will was the same, that the copy is the same, the content of the copy is the same as the content of the will was actually signed. Here we have filled in those blanks. There is no mystery, as appellant has asserted. Will was downloaded in the same form that it was emailed, that the decedent emailed it to himself, and that he signed. All that occurred the same day. There's no different version. There may be handwriting added to the will at some point, either before or after execution, but that has nothing to do with whether the will is admitted to probate. That could raise an issue as to the effect of the handwriting once the will is admitted to probate. And as far as the spoliation argument goes, as far as I can tell from the cases cited, those relate to spoliation of evidence in a case that hampers or affects the ability of the affected party or the opposing party to prove the prima facie case that they have asserted. Some of the cases there deal with not only documents but actual things. In the Golden Yachts case at 920 SO2D 777, there was a destruction or losing of a boat cradle that was the item that caused the injuries. It would be hard to prove a defective item if that item no longer exists. So there were sanctions entered there. We have the Adamson case, that is the shredding of medical records, in a tobacco litigation case. Here, the will is the subject of the case. It's not evidence or merely evidence. It's the whole subject. The case is a case to establish a lost or destroyed will. If the will hadn't been destroyed, if Miss Douglas had not destroyed the original pages, but for the signature pages, there would have been no case on a petition to establish a lost or destroyed will. If anyone was affected negatively by her destruction of the will, it was her. And she preserved the original and had it admitted to probate as the original will, then Mr. DeGauli's clients, the appellant, would not have any standing. The will would have been admitted to probate and the beneficiaries would have been established without the appellant being involved at all, which also affects the appellant's other arguments related to Miss Douglas's conduct with the decedent's assets after his death. As the trial court found, Miss Douglas was unsophisticated as to these types of matters, did not know the proper way to handle things, but everything she did based on the testimony with the permission of Bridget Tucker, who was the other beneficiary, the only other interested person under the terms of the will. And if there are no questions from the panel, I'll just conclude and ask that the court affirm the trial court's ruling that the will dated October 11th, 2022 was properly admitted through a correct copy, and further affirm all aspects of that decision. Thank you.
Thank you, Mr. Blue. DeGauli, you have 4 minutes.
Thank you, Your Honors. With respect to this correct copy idea that The argument is completely reconcilable with the Supreme Court's decision in Parker's estate. At that time, that court considered a certified question, answered the certified question by holding that a correct copy is an identical copy, such as a carbon or photostatic copy. What the court analyzed was the fact that the statute breaks it down into two. You have to have two disinterested witnesses, or if you only have one, you can offer a correct copy. The court ended up saying, well, the testimony of one witness suffices when you have a correct copy. If the legislature had intended for a substantial copy to be admitted to probate on the testimony of one witness, it wouldn't have made the distinction. And so you can't get around, nobody can get around. This is nothing more than a substantial copy. We don't know whether the handwriting was there on the day it was signed. We don't know whether it was signed afterward. We do not know whether it had a page 1 when it was signed, or whether that page 1 was ever there or whether it disappeared later. This can't possibly be an identical copy of anything. And the idea that counsel raised was that there's no difference between the probated will and the one on the phone. Well, the probated one, the one on the phone has a page 1 and has no handwriting on it and is not signed. You can't possibly make a cogent argument that the electronic file on the phone is an identical copy of the will that was admitted to probate. Now, with respect to
Is that his position? I thought Mr. Blue was telling me that she found the documents in the decedent's house. And after a while, she couldn't stand the smell. She kept the original signature pages. She made a photocopy of every other page that she found. So why do we need to make this connection to what you downloaded on the phone?
Well, if we accept the proposition that she photocopied whatever she found, then that's why we need a disinterested witness to tell us that what she found really was the will. Because let's say she had found only the odd pages or half of it, or only the signature pages, or the first page was there and had handwriting on it. We don't know whether that was the will or not. That's why, in addition to, you got to come up with a correct copy, you've got to have at least one disinterested witness. The appellee has not suggested to this court that a disinterested witness testified. There was no disinterested witness here. That is indistinguishable from the Brennan decision, in which it was agreed there was a correct copy, but there were 0 disinterested witnesses. You cannot, under those circumstances, comply with the statute. And so the idea that, well, it's irrelevant that the handwriting is there, or that the page is missing, we really don't know whether the handwriting was there. Maybe page 1 had handwriting on it. Maybe it was there when he signed it. Maybe it wasn't. A disinterested witness has to tell us that's the will that this copy is a duplicate of, or in the Supreme Court's language, an identical copy of. And in the absence of any disinterested witness, you simply can't meet the statute. Now, the idea that we should soften it and take some sort of other evidence, well, that's indistinguishable with the decisionary authorities as well, but it actually doesn't even make any sense. Yes, there are other types of instruments that we need all of your original signed pages for, but
All right, you got 20 seconds.
This is a statute.
Need to wrap it up. You have 20 seconds.
This is a statute that makes, for good policy reasons, reestablishment of that instrument difficult. And that's why it's different than other instruments for which we might or might not need all of the signed pages. Thanks, Your Honor.
Thank you both. Happy holidays. Enjoy the rest of your day.
Happy holidays.
You too as well. Happy holidays.
So our last case is Charmant Theodore. I think Ghislaine Theodore and Perry's et al. Parties ready? Council ready?
Good morning, Your Honor.
Morning.
Lindsay Mosinski for the Perrys, who are the appellees.
Darius. All right.
Good morning, Your Honors.
Morning,
Jacques
sir.
Darius.
Yes, sir, Mr.
Presenting
Darius,
the
you are the
appellants.
appellant. Would you like to reserve some time for rebuttal?
Yes, Your Honor, I would like to reserve 3 minutes.
You got it. You may proceed, sir.
May it please the court. This case is an appeal from a summary judgment which declared a 2006 judgment of easement void. The trial court committed reversible error because appellees sued the wrong parties. If they wanted to vacate the judgment, they needed to sue the parties who obtained the 2006 judgment against them. And if they wanted to show that the judgment has no effect upon them, then the remedy lies in a quiet title action, which they have filed and is still pending in the trial court.
The Perrys were not served in the 2006 litigation, is that right?
Your Honor, we don't know that. That is a disputed fact. Although the trial court did find that they weren't served.
Trial court found the judgment to be void because there was lack of service over the Perrys, correct?
That is correct.
So what can you point us to that indicates that there's something in the record that indicates the
I did not hear the last question, Your Honor.
Is there anything in the record that indicates that Perry was a party to the 2006 lawsuit?
Your Honor, the record was destroyed. And keep in mind
I understand the record was destroyed. I understand. Apart from that record that was destroyed, is there anything else?
No, Your Honor. What we know is the history of the case. The case was previously filed against the Perrys in 2004, and was dismissed. We don't know what happened between the parties, and that again goes back to the issue of the need to sue the right parties.
Judge Nash went round and round with relevance or lack thereof of the 2004 litigation. What basically the question he was asking was, what does that have to do with the 2006 litigation?
Well, Your Honor, if they sued the right parties, they would have known whether or not there was any waiver, any agreement between the parties, or what happened in that case, what caused the Berries and the Price to refile, not naming the Perrys. And in addition, the main thing as far as naming the Perrys weren't indispensable parties in this case either, and the trial court never reached that point. If the easement already pre-existed from the time the parcel was partitioned with the landlocked portion, in which case the Perry's presence, they weren't indispensable, the presence would not have made a difference. And that goes back to the issue of standing because it's not redressable.
Perry essentially is saying, how can you find an easement over my property with litigation where I wasn't even invited to the party? I wasn't there, wasn't served. You can't show me that I was. Why am I here?
Well, to address that part of it, Your Honor, if the easement were pre-existed at the time of partition, the order merely recognizing that, declare that that easement exists.
Go ahead with your presentation.
Yes, Your Honor, other than wrong parties, and again, the courts, most of the cases that the appellees have cited pertain to cases where they sued the right parties. Again, if they do wanted to attack whether or not the judgment is void, they would have to go ahead and sue the Berries and the Perry and the Berries and the Price, not the Theodore, because the Theodores were not party to it, and they were not the adverse party in the 2006 lawsuit, and that's the critical point in this case. In addition to, and that goes to the issue of standing as well, because they cannot show causation if they are suing the wrong parties. They cannot show that the Theodores essentially caused the easement or the order, the judgment that they are attacking to be rendered.
Let me ask you this question. The judge, I think, only relied on one case in his order, which is Westcott versus Westcott, 444 Southern Second 495. Judge found that to be a controlling case over the current case that we're talking about. Do you agree or not?
No, we disagree. Westcott pertains to a divorce case where the spouse essentially alleged intrinsic fraud. In fact, Westcott, to some extent, that supports our argument that in that case, the court find that there was no intrinsic fraud, the judgment could not be invalidated. We're not saying the appellees allege fraud here. They implied fraud, but they don't really allege fraud because they are saying that they weren't named when the face of the judgment says that all necessary parties were served. But all necessary parties were served. So if we look at the face of, if they are contesting what Judge Honeywell, I think Honeywell found in granting that 2006 judgment, they essentially inferring that this is a fraud case. But if we go back to Westcott case, the Westcott case involved the two parties that were involved in the original case. So to the extent that the court cited it, it's simply citing it to say, yes, you can bring an independent action, because there was a lot of argument in the transcript about whether it should be via motion or independent action rather than the substance of the issue, rather than the substance of the issue. It's not whether or not we're not saying they cannot bring an independent action. We're simply saying if they are bringing independent action, it must be against the party involved, the adverse party involved, who obtained that judgment against them. To the extent that they are saying that this judgment, if they're claiming the judgment is not applicable to them because they weren't served, then that's a quiet title issue against the Theodores, not the count. Initially, that's what they filed. But in the quiet title, the court would have to determine whether or not the easement pre-existed. So by attacking the judgment itself and avoiding I'm not saying that they're trying to avoid the quiet title issue, but that issue will have to be determined in the quiet title, which is pending. And granting the summary judgment, we did try to see if the court would stay the order until the quiet title issue is resolved. Unfortunately, that was not granted. And it's not just Westcott. There are also several other cases. All the other cases that they have cited, we've gone through them, and they all involve the same parties. And there are cases as well from this court and other courts that suggest that it needs to be the adverse parties. If we are talking about Westcott, since Westcott involved a fraud allegation, in Westcott, if we go back to Rule 1.54 B, the interpretation of that rule, in that rule itself, it says adverse party. So filing it against a non-adverse party in the 2006 judgment is improper. And granting it is improper. So reliance on Westcott for that proposition is misplaced. And going to the standing issue, actually, before I go to the standing issue, I think in this court in City Pinellas Park versus Matthews, which we cited, this court found that appellant who acquired from a parcel of property, which included a land covered by deed to the city, had no standing to bring lawsuit to declare it void for lack of consideration. Instead, the court suggested that the remedy is in a quiet title lawsuit, and which is exactly what we're suggesting. The remedy is in a quiet title, and it is pending. And that issue would have been addressed at the quiet title, but there would be more determination, such as whether or not they were indispensable parties, whether or not the easement already existed, and that's what we're asking. That it's I won't say premature, but giving the judgment at this stage when the issues are still pending harm the Theodores. again, assuming the Perrys allege that they are injured because the easement traverses the property. But that injury presupposes, we go back to the issue of presupposes the easement did not exist before the judgment. The easement is established by operation of law at the time of the partition where the property was left landlocked. The judgment in 2006 merely recognized, and it goes to the parties, it cites the whites, and that's might be one of the reasons why again, we're speculating here, why the Perrys might not have been named, because they would have taken subject to that easement at the time of partition. The judgment does refer to whites and heirs and subsequent. So the Perrys in that case would take subject to that partition, which caused as to that easement, which happened at the time of partition. There were other issues in this case, but the main two, Your Honor, before I rest on my brief, the main two pertain to wrong parties and lack of standing.
Okay, thank you.
Thanks, sir. You'll have 3 minutes. Good morning. Did you ask for 3 or 4?
3.
You have 3. All right, so thanks. Yes, ma'am.
May it please the court. Your Honor, as Mr. Darius stated, the brief for the appellants argues that the Perrys lack standing and that there's genuine issues of law and disputed material facts. But at the motion for summary judgment hearing below and today, it's not an opportunity for the Theodores to argue or decide whether they have access to their property and whether or not their property at one point may have been landlocked. It's an opportunity for my clients, the Perrys, to prove once again that they were deprived of their constitutional due process rights. This is not an easement case. It's not an access case. It's a due process case. There is no dispute that the Perrys were not named in the 2006 case. And that was shown by admissible evidence provided at the summary judgment hearing in the trial court below, which included affidavits of all 3 Perry parties, as well as the 2006 docket, which was created by the clerk of court, as well as the individual entries, and a certified copy of the final judgment that was entered in the 2006 case. The Florida rules of evidence, they allow for the docket, the entries, and the recorded documents in the official records to be considered self-authenticating and as admissible evidence. As you have seen through your review of the record.
What do you make of Mr. Darius, if I understand him correctly? The notion that the Perrys took their property subject to a pre-existing.
What do I think of the notion that my clients took the property?
Does that make any difference? If I understand Mr. Darius correctly, they took their interest in their property.
So, Your Honor, that is still to be determined and is pending before the lower court. If there,
That's the quiet title action.
There is an alternative count for quiet title, which is also still pending and may or may not go forward based on the rulings today and the counterclaim that has been alleged and is still pending in the case below. But whether or not there was already an easement over the Perry property is in dispute and is contested by the Perrys. But there was no dispute that the Perrys have been record owners of this subject parcel since 1975. And so any claim that they could have been encompassed in a catch-all phrase that's included in the case style of the 2006 case is misplaced. The unknown heirs, devisees, assignees, etc., is just there as a catch-all. But the Perrys were not unknown. as recorded in the official records by all the multiple deeds and conveyances through a probate case, the Perrys were record owners of this subject parcel. And so they were not unknown, and they were not considered to be parties in the 2006 case, not by the case style, not by the language within the final judgment or anything thereafter. Now, because they were not parties to that case and because they were deprived of their real property, they had standing to bring an independent action to vacate the 2006 judgment as void to the extent that it affected their rights. As stated within the record, there are 2 paragraphs, generally speaking, of a legal description. Only one of those paragraphs encompassed the Perry property, and that was the only paragraph that was requested to be vacated as void. Now, trial courts, the general power of the courts include the ability to entertain a separate action to set aside a judgment. 1.540B does have a savings clause within it. It does not limit the ability to only intervene in a lower court action. It allows for an independent action to be brought. And that's also discussed within the author's comments for the 1967 amendment to Rule .1540B, which is described in the Westcott case, which Judge Nash did rely upon. Standing also requires a plaintiff, such as the Perrys in the court below, to demonstrate they're going to be reasonably affected by the proceedings. It depends on the nature of the injury asserted, but not on the merits or elements of the underlying claim. And so here we show, unlike what the appellants believe should be required to show standing under Article 3. This is an Article 1 case where the due process rights have been violated of my clients. They were indispensable parties to the 2006 case because they were record owners. And it shows that the 2006 judgment is void because the trial court lacked the subject matter jurisdiction. The trial court in the 2006 case lacked personal jurisdiction over the Perrys since they were not parties. And there was also a violation of the Perrys' due process rights because they weren't guaranteed notice or an opportunity to be heard. As for any other potential issues of law or fact that may have been contrived by the appellants, there just weren't any. And there was a very extensive order entered in by Judge Nash in the trial court below, showing that the affirmative defenses that were brought were insufficient to overcome any type of burden of proof that the Perrys met. So with the evidence that was brought forth below, the Perrys met the initial burden of proof. And then it shifted over to the Theodores to show that there's a genuine issue of material fact and that summary judgment should not have been granted. They didn't do that. All they could do was provide self-serving affidavits regarding whether or not their property was landlocked, which was not an issue within the summary judgment. And they provided an affidavit by their counsel in the trial court below that tried to proffer things regarding the 2004 case, and maybe the Perrys had notice. Instead, the Perrys, with their affidavits, showed that they did not have notice of the 2006 case. They did not have notice of the 2006 judgment, and they did not have notice of this until 2020, which is when they tried to resolve issues and were unable to, and therefore brought the lower case to lawsuit. Based on the fact that the Perrys had standing, based on the fact that the Perrys' constitutional due process rights were violated, the judgment in the 2006 case, which was entered, is void and was properly vacated to the extent that it affected the Perrys' personal rights and their real property personal rights as well. And so we do, I'm not sure if the panel has any questions for me, but we do rely upon the arguments within our answer brief and the record that has been presented regarding the due process violations, and request that the summary judgment entered in the trial court below be affirmed. Thank you.
Thank you. Thank you, Darius.
Yes, Your Honor. We're not saying that if the non-party who failed to be notified, due process is not implicated. What we are saying is any injury the Perrys suffered cannot be demonstrated independently without reaching the issue of whether or not the easement pre-existed the 2006 judgment. It is ironic that I understand counsel pretty well that counsel is asking that the 2006 judgment be found void because they were not party, but they are suing another non-party to have that done. And that is the gist of our argument. I understand that the issue of indispensable is still pending before the court, but if it's still pending before the court in the quiet title argument, but it also is an underlying fact in the 2006 to consider if we get past the issue they sue the wrong party, and if we are getting into the standing issue when we are getting at whether or not this is justiciable in the 2006 judgment, avoiding of the 2006 judgment, we have to reach that part, because whether or not they were indispensable party matters whether or not the court can actually find a solution that helps them. The bottom line, Your Honor, is regardless of the argument, the case can be summarized as the Theodores moving to a new property, and their neighbors try to impede their use of ingress, sue them to quiet title, and after the records were destroyed, also sue them to invalidate a judgment they were not part of, and shifting the burden upon the Theodore to prove something that happened in that 2006 litigation that they had nothing to do with, and which makes it a virtually impossible burden to meet, because they weren't there. They can only speculate of what happened in that part. That's the reason why we want the right parties to be sued. In summary, Your Honor, the judgment on its face does not appear to be void, to the extent that the Perry's wishes to assert that the judgment is not applicable to them as to the Theodores, then the quiet title is the proper action. Plus, the notion that they only find in that is into 2020 about the easement is questionable, because the easement was reported in 2010, and the Theodores have been using it, the easement, and that would be difficult to understand that they did not know about the easement.
Thank you very much. Good to see you both. Happy holidays to both.
Thank you.
We are adjourned.
Thank you. Happy holidays.
Happy holidays.
Thank you.